Brilliant. Good morning, everybody. So this morning, it feels strange saying this morning, not this evening. We're joined by Keir Monteith, King's Counsel. Keir is a criminal barrister and a recorder as well, from Garden Court Chambers, and has regularly worked on murder trials involving joint enterprise issues. And he's also a founding member of Art Not Evidence, which I'm sure a lot of people have saw across the different social media pages, and that is aimed at trying to create a more a fairer justice, criminal justice system, especially in those cases where the Crown and the prosecution are adducing drill lyrics to try and paint a picture of a defendant and what role they've played within a crime. So I'm really, really pleased to have Keir on this morning. He was the first King's Counsel I reached out to as well, and asked if he would come on the podcast, and I got a great yes. So I was really happy about that, and I couldn't believe it actually as well. So a bit of a wholesome moment for me this morning. I'm going to ask Keir a couple of questions on the following topics: murder and joint enterprise together, and then also Art Not Evidence and what that is all about and how it got set up. So the first question, Keir, if you don't mind, if I've introduced you correctly, that is, please make you talk a little bit about joint enterprise and what you think could be changed in terms of how it's used at the moment in the framework.
Well, before that happens, Ellie, just to thank you for inviting me on, and I'm very humbled to be your first King's Counsel, and it's great we've got this unusual connection, even though we've never sort of met each other. Both went to Essex University.
Yeah, absolutely.
Yeah, and we were just talking about that before the recording started. So absolute pleasure to be on here. And I've got to say, before I say anything, just in case something happens, that I'm speaking in my personal capacity, not in any of those other things that you mentioned in the very kind introduction that you gave me. But I'm sure I won't say anything untoward. So going back to your first question, rather than rambling on, there's a major problem, I would say, with joint enterprise, and particularly in relation to black defendants. There's a horrendous statistic, and it's a recent one that came out in 2023, that if you're black, you're 16 more times likely to be charged for joint enterprise allegation. And we haven't probably got time to do all the pauses I would normally do if I was addressing in an audience, but it's just worth letting that sink in. If you're black, 16 more times likely to be charged for joint enterprise allegation. And that's because there's institutional racism, unfortunately, not only within the police, but in the Crown Prosecution Service and in the justice system. And that's the thing that needs to be combated, because it destroys people's lives, the family of the people who are wrongly alleged to be involved, and doesn't bring us justice.
Absolutely. And when you talk about institutional racism, within, the different not organizations, but, the different levels of people, do you think that that's something that will always be around and will never truly be fixed? Or do you think it can come to a point where one day it is completely fixed?
Well, we'd have to reach a utopia, and we haven't quite reached that yet. So I doubt it will ever. I mean, I'd say myself, I'm racist. It would be unsurprising if these institutions didn't have a degree of racism in them, because it reflects society. But when they are there to try and ensure justice and fairness, every effort needs to be made to try and ensure that you get as close to that as possible. It's never going to be perfect, no system is. But the first step, and it's just about honesty, is saying there is institutional racism. And once you recognize a problem, then you can start to do something about it.
Yeah, absolutely. Okay, thank you very much. So, joint enterprise, as I understand it, is where a secondary party can be guilty for the principal offence, so the say for example murder, and that may be through them aiding, abetting, encouraging or assisting. And when you have a trial that where it's multi-handed defendants and it's murder under the legal doctrine of joint enterprise. Do you explain that to a jury, and do you actually mention what you've just said there about how you're 16 times more likely if you're black to be found guilty?
So there's a general reticence amongst lawyers, I include myself to an extent,
Mhm.
in mentioning racism or institutional racism, because the perception is that it gets the backs of judges up and or juries, and better to concentrate on what the evidence suggests or doesn't suggest, proves or doesn't prove. But I've got to say, recently, over the last maybe 4 or 5 years, I've changed my view. And I've come to the conclusion, because it is so endemic in the system, it's better to speak truth to power. And I did that in a recent case, and talked about, it was a murder case, joint enterprise, and I talked about the problems of institutional racism and how that explains why my client had been prosecuted for something he clearly hadn't done. And then I went on to deal with the lack of evidence in that particular case. So it's how you get the message across. But I think it's important to be honest with the judge, judges, if it's the Court of Appeal, and the jury. And as long as you're accurate about what you're talking about, you should end up with the right result.
And recently you've been working on an appeal, haven't you, to go into the CCRC with the 3 defendants that were found guilty, amongst, I think there was something like 10 or 12 others. There was a lot. I was reading about it. And that's all about institutional racism as well. So have you managed to find a ground of appeal um, to do with racism, or is it purely like to do with the evidence and things like that?
So it's linking it all up. So what you're talking about there is a Moss Side case, a series of convictions in 2017, which is presently before the Criminal Case Review Commission, and we're very much hoping for a result in that particular case in October, November of this year. But I'll just give you just a little example of how I would say that case went wrong. It's a murder case, and the prosecution, as part of the evidence against the defendants, adduced a video. It was a rap video. And none of the defendants in the trial was the rapper. They didn't use any of the lyrics in the rap as part of the evidence. They just said, here's the rap video. And in the Preston trial, the judge, and it was a High Court judge, very experienced judge, directed the jury that if they found that a defendant possessed a video, and I sort of say to myself, how do you possess a video? But it would include a client of mine, Mr. Williams, who had a screenshot of the video on his phone. If you possessed that video, or you participated in that video. So none of them are rappers. This is just lads in the background, not rapping. So participating in that way. The judge directed the jury that you could come to the conclusion that they were a member of a violent gang. And to me, it's just incredulous that that suggestion and direction could have been made to a jury in a murder case. And
Mm.
if you conclude that they're in a gang because they appeared in a video, then it's a very short distance before you start coming to the conclusion that they had the necessary intent and association to be guilty of murder. That's just one example of how that particular trial went horrendously wrong. There's loads more, but we won't have time for it. And again, it's in the process of being dealt with in the Criminal Cases Review Commission. Another example of raising the issue of racism and institutional racism is a Court of Appeal case which I was successful in. That's Ade Adedeji. And in that particular case, he'd been convicted of conspiracy to commit grievous bodily harm. And part of the explanation, again, for how that case went wrong was the issue of institutional racism. And we adduced a whole load of evidence, expert reports, and witness statements and analysis, and put it before the Court of Appeal. And that case actually was supported by Justice, which is a independent organisation that is involved in these sorts of things, and they intervened. And although we had all of that support, all of that evidence, if you look at the leave hearing and if you look at the full judgment, you won't find those two words, institutional racism. The Court of Appeal didn't even engage with the argument to come to its own conclusion. Let's say it doesn't exist. They just ignored it. And that's, in 2025, a real sadness.
That speaks volumes, doesn't it, really? And also, so just one more question regarding the Moss side case. The guy who was in charge of running the youth activities and made the video for the children to all get together and, well, the boys to all get together and stuff. He said that in at one point his frustration was that he never got called as a witness, and if he did, he would have been able to say these people are not gang members at all. It was, you know, a youth activity, it was a youth gathering. Why do you think that, and do you think that would have made material difference if the defence would have called him? Would you have called him if you were the defence in that case?
Yeah, so I suppose on one level, I can't get into too much detail because it's
Oh,
literally going through the Criminal Cases Review Commission.
of course. Sorry.
But the actual answer is, yeah, of course. This is a person that, on the face of it, because it's been reported in the newspapers,
Yeah.
was able to provide fresh evidence. And obviously, you've got to look at the situation as it presents itself in a trial. But there would be very good reasons for calling that individual. But as I say, I've got to be careful about it because it's still going through the courts.
Yeah, of course, of course. Sorry, I'll stop there. So next question, how do you look to establish or undermine, let's say let's take it from a defence angle. How do you undermine intent and foresight in joint enterprise cases? Because the ones that I've read, I struggle so much with how a defence barrister would even start, even though sometimes it's like clear as day. How do you actually undermine intent and foresight, or is there any sort of rules that you regime that you go through to tick those boxes to make sure you've done?
Yeah, so it's and that's why it's a joy being a barrister. Every case is different, so often you have different approaches. You know, no case is the same, or it's rare that that's the situation. But you just go back to, for me, anyway, you go back to basics. You sort of say, well, what have they done? What has the individual actually done? And as long as you're not representing the principal, who may have shot or stabbed someone, you're often able to answer that question by saying very little.
Yeah.
Yeah, they haven't knifed anyone, they haven't shot or strangled anyone. What have they done? So yeah, you can go back through many cases now based on CCTV and establish that they are with maybe one or two, three or four, or maybe with a group for a period of time. But that's not murder. That's literally walking along the street or in a train carriage or in a car, and so on and so forth. So I always concentrate on acts or indeed omissions.
Yeah.
And then in particular, at the time of the murder, if it can be timed, sometimes it can't be, very important to establish what's going on at that particular time. And if you concentrate on that and your client, then there's a greater chance of getting acquittal. But it's always difficult because the bar for joint enterprise, as you indicated at the beginning, is so very low. Encouraging, what's that mean in reality for a jury? Or assisting, and the bar is so low. And then if you throw in some stereotypes, if you throw in a gang narrative as a prosecutor, in terms of proving intent to kill or commit grievous bodily harm, it is unfortunately, with a degree of persuasive advocacy, quite easy to do. So it's hard and difficult in these cases to deal with a joint enterprise prosecution.
And that leads me on to the next question, actually, about, the roles that the social factors play into these trials and gangs and these type of narratives that do get brought in by the prosecution. You think they have a really damning effect overall? Because if it wasn't for these extra narratives getting added on and placed in, then perhaps the juries would just look at the fact as it is.
Yeah, absolutely. And there's an ongoing problem, and I can only, I guess, speak for myself now. I'm however million years old. Yeah. I don't know what's going on, and I
Yeah.
suspect this applies to other barristers, but I will only speak for myself with social media stuff nowadays.
Mm.
I do not, generally speaking, understand it. But a lot of that evidence ends up in trials. It's phenomenal how much stuff ends up in trials, whether that's pictures or tracks in terms of rap or drill, or videos. And very often, from what I can see as an old bloke, it's got nothing to do with the allegation that the person has faced. And in terms of how we're sort of traveling and the direction of travel in society and how things are now presented in social media, there seems to be a lot of exaggeration. More than when I was a kid. I'd certainly exaggerate about my capabilities, but there seems to be a gross amount of exaggeration and bravado that's knocking around. And what was really interesting for me is exposing the sort of hypocritical nature of the situation, of maybe what I would describe as the establishment, using exaggeration or metaphors, I suppose, and contrasting that against what happens in court. So there's a guy called Drill Minister, and he was commissioned by Channel 4 to put together a rap or a drill that used quotes for MPs. And a number of those quotes from MPs, seen in isolation, are quite disturbing. So I think one of them was, "I won't knife you in the back, I will knife you in the front." That was actually said by an MP. Another one was, "I will not rest until she's chopped up in bags in my freezer." So it's worth, if people got this far in this interview, going off, typing in Drill Minister Channel 4 and listening to that rap, because it's only 2 minutes or so long. It's very powerful. But all of those MPs, if we had a chat with them, if you had them on here, would say they didn't mean it. And I'm sure they didn't literally want to stab anyone, whether it's in the back or the front, or whether anyone should be chopped up. But that type of stuff, and I know we're sort of smiling even though it's in the morning, that side of stuff features in murder trials, particularly, I've got to say, in cases involving young black men.
Mhm.
And it shouldn't.
No,
There's a major problem there, and a gulf between the people in court and in terms of the lawyers and the judges and the defendants and the youngsters.
and I find it really ironic because the previous episode I did a couple of weeks ago, we discussed a similar thing, and I said it's so ironic because they're trying to almost do better for themselves and get out, and whether that be making music or whatever they're doing, and they're almost getting it shot back in their faces. It's getting used as a part of evidence to say that they've been involved in a gang, and that gangs are all killers. And I just find it really sad for them that they're just, constantly trapped in a cycle of, well, if they do something, it's not good enough. They're damned if they do, they're damned if they don't, type of thing.
Yeah. And going back to that Mossai case, where it was described as being a gang video, it's now had 102,000 hits on YouTube, you know? And it should be put up there as an example of positive
Mhm.
activity rather than me using it as a ground of appeal in a murder case. We should be so much better than that.
Absolutely. Also, how well do you think juries understand joint enterprise? I know that obviously they get talked through it and they have the route to verdicts and things like that, but how well do you actually think they're understanding that? And yeah, could anything be done, I guess, to make them to help them understand it a little bit better?
Well, so yeah, there's a sort of contrast there. So I was involved in a joint enterprise murder case back end of last year, so 24 into 25, 7 defendants, and there was one murderer, but just and very sadly, a knifing in a park at approximately 3 minutes to 9 one summer's night. And in that particular case, I actually came to the conclusion, along with the legal team that was involved, that the evidence against my client was so weak that I didn't need to ask a single question in 4 months. So no cross-examination of members of the public, no cross-examination of police officers or scientists or co-defendants, absolutely silent from me. And got to the end of the prosecution case, didn't call my client. And in fact, 5 other defendants weren't called in a murder case. And my speech to the jury was about 25 minutes. And I did mention in that the issue of institutional racism.
Mm-hmm.
And in that case, 6 defendants were acquitted of murder and manslaughter. So that includes a number who didn't even have to address the jury. And it was clear as day, as far as I was concerned, that my client and indeed the others were not guilty, because it wasn't a joint enterprise murder. This was, sadly, one individual who came to the conclusion that they would use a knife, and then we had the disastrous consequences. So that's 2025. And it seemed to me the jury were very clear, understood the issues of joint enterprise, and rejected totally what the prosecution were suggesting, and quite rightly too. And there's a document out, a report out by the Charity Appeal that actually mentions that case along with a whole load of others in a project that they were conducting in watching trials in the Old Bailey over a period of 6 months. And it does indicate, certainly in that period of time, that juries were rejecting this notion of joint enterprise on a significant level. So I think in that study, it was about a third or over a third of the cases saw 0 convictions for the most serious charge. So they were being led through these trials by the prosecution and rejecting that narrative. On the other hand, certainly if you look at the work that Jengba has done, there are thousands of people who are wrongly incarcerated on the back of joint enterprise. And people I know, and I'm representing them, have also been wrongly convicted. So it just demonstrates that in certain circumstances, yeah, juries do get it, do understand it, and will acquit. On others, and it might be because evidence has been wrongly admitted, juries are unfortunately wrongly convicting individuals on joint enterprise. So it's a real mixed bag. But at the end of the day, in my view, really what should happen here is the prosecution should be making the decision not to prosecute in a significant number of cases. You shouldn't be trying it out in front of the jury. They should be assessing the evidence properly, and limiting the use of joint enterprise. And that would be good from a justice point of view, but also a community point of view.
Absolutely. Thank you so much. So I guess that concludes the joint enterprise and the merger, the chat that we've had, and the questions that I've got to ask. If you've got anything else to add.
Well, it's probably a big long list, but let's move on. I'd be here all day if I was allowed to speak about joint enterprise. So
yeah, absolutely. Okay, so then rather we'll move on to Art Not Evidence, which I think is fantastic. I've followed the LinkedIn page, I've shared it around. I actually stumbled across Art Not Evidence a couple of years ago when I was working on a case that I spoke to you about on the phone the first time.
Oh yeah.
That's actually the first time I ever stumbled across it, and I said it to my director, and I said, look, this is fantastic. And he was like, yeah, well done, fantastic, you found something on the internet. You're doing good. Come back to me when you've got something else. Yeah, I think it's fantastic. as I've just said to you a couple of episodes ago, I was saying how I find it really ironic that they're doing things, these young black boys are doing things to help them, and girls are doing things to help them get out of
And
the
girls,
what they
yeah.
call the hood, you know, or whatever, and they're getting it just smacks back in their face, really. I do think it's outrageous to say that because somebody's rapping, and this is just my standpoint on it, especially because I had that personal experience with it, which I told you about, find
Yeah.
it frustrating and outrageous because I think the minute that it does get put into or before a jury, like you said, I know it's a mixed bag, but sometimes that can be quite damning. Sometimes they can take that route and think, okay, yeah, they're all affiliated in a gang, because I don't know, they may be talking about op members or whatever. But I just find it frustrating. I won't start either because I'll be there all.
Yeah.
But you are, I found, one of the founding members of Art Not Evidence. So how did that? How did you get involved in that? If you don't mind me asking, and how did that start? Obviously, I know it's passionate. You're passionate about it. It's close to your heart. But how did you get involved in that?
So it was Ellie Brazil, who's really the founder. Um, uh, Probably about 2 years ago, contacted me, and basically said, would I be interested in being involved in setting up an organization, a bit like what was happening in America, to try and do something about the prosecution, the state's use of music in really serious cases. And I said, yeah, of course, I'd be really happy to be involved. But Ellie certainly was the one that started it off. But it just reminded me of the first time I was aware of music being used in murder cases. I just couldn't believe it. I was in the Bailey, and we're in the middle of a murder trial, and we'd just been given a statement by the prosecution, and it was from a police officer. It wasn't from a music expert. It was from a police officer who provided all these links to YouTube videos, which may or may not have involved my client, and they were trying to use that as evidence in a murder case. I mean, it was absolutely and utterly outrageous. So there was lots of reasons as to why I'd want to get involved, and here we are, 2 years on. We've got a fundraiser which I'm going to advertise
I was just about to say that.
blatantly to everybody who's listening. 24th of September at Clifford Chance Canary Wharf. It's going to be a great evening. I know you're coming along.
I
Ellie.
am coming along. That's correct.
Even more reason for people to turn up.
Yeah, I agree there. Life and soul of the party.
Exactly. Great music, obviously.
Yeah.
And importantly, we've got our website, and on there's draft legislation that's being championed by MPs in the Houses of Parliament. And it's there to limit, it's not to exclude totally, but just to limit the use of rap in criminal courts. And where at all possible, and this can't be controversial, use other evidence like forensics, like cell site, like witnesses, to prove the case rather than relying on music. And that can only be a fair and proper way at this point in time to try and prove serious charges.
I think the first time I heard about drill being used from the prosecution was, I think it was there was a rapper called Digger D, I think it was. I watched it on Channel 4. It was a
Yeah.
really, really good. His solicitor was fantastic. And they basically said to him, you know, if you even make another video, you're getting recalled back to prison. And it's like, I think that's what they said in part of the documentary. And there was other things in it, of course there were. But he basically got him and his couple of friends got banned from mentioning absolutely anything within the lyrics, you know. And his solicitor was ringing him and making sure he was abiding by it every day. And he was like, I'm finding it so frustrating in the studio because I don't know what else to say. We talk about the things that we see, and that's what the music is all about. It's about showing real life and not necessarily encouraging it.
Well, I think, yeah, so there's one or two things to say about that. So he's subject to a criminal behaviour order,
That's the one.
which, if he breaches, he is subject to recall to prison. So that's hanging over his head after he's been released, after he's done his sentence. And so the first thing that one needs to ask oneself is that a good plan at all? Because it puts a real pressure on him, because he's the one actually ultimately, as much as he can seek advice from people, that has to decide what he does put out there and doesn't put out there. And it's not just tracks, it can be just social media, it can be presence in certain situations. So it's, for a youngster, it's a real pressure on them at a time when many other people who leave prison, that's it, quite rightly, get on with your life. And it has this sort of chilling effect as well, not just to him, but to other artists, maybe people who aren't as famous, to self-censor because something they might put out there that's provocative, and this is a big thing about any entertainment, including rap, it isn't a lot of the time true. You watch John Wick, yeah? That's incredibly violent, but very successful. But it's not true. It hasn't really happened as far as I'm aware. And it's no different for entertainers. And as I said before at the beginning of this, people are a lot more provocative nowadays. Whether that's good or bad, I really don't know. But it's a matter of fact. And that's how you get your clicks. That's how you get your views. That's how you get your artistry monetized. And that's what happens in reality. And there's a real danger, especially when it's directed at just black artists, of not only putting them under pressure, but self-censorship. And that's a chilling effect in relation to freedom of speech.
Absolutely. So, in terms of your involvement with Art Not Evidence, what's your proudest and most fulfilled moment?
So I think it's connected really with my sort of day job, and it was the appeal of Ade Adedeji, a young lad who I was actually supposed to be meeting to congratulate on him getting an unconditional offer to study law at university, but instead he was being prosecuted wrongly for this conspiracy to commit grievous bodily harm. And he ended up actually doing about 3 years in prison. Well, first youth detention, then in prison. And through a lot of hard work, and that was a whole legal team, so not just me, but other lawyers, Audrey Mogan and Zach White, we were able to get the conviction quashed. And behind that, there was a lot of support from Art Not Evidence. And I'm really proud to say that literally as we're speaking now, what time is it? Yeah, just 9 o'clock. He's got a internship with Clifford Chance. And the contrast between the fact that if we hadn't got that conviction quashed and had that support from Art Not Evidence, he would be in jail now. And I'm not just thinking about it this literally this moment in time, the contrast between what his life would have been and what his life is now is phenomenal. But I will never forgive those that tried to keep him inside, because when we were running this appeal in the Court of Appeal, that was the approach of the prosecution. And if they had succeeded, he would be in jail now. But fingers crossed, he's going to go on to be the most fantastic lawyer that we've seen in decades.
Yeah, absolutely. And I mean, he's got the first-hand experience as well, so he'll have resilience like no other, and he'll have passion to help other people in the same situation as him. Does he want to do criminal law as well?
I sort of on one level say I hope so,
Yeah.
because there's a sort of perfect circle in terms of his ability to represent individuals.
Yeah.
But at the same time, it's hard out there. But you're going to get there maybe first, Ellie. I don't know.
Oh, I hope so. Pray for me anyway. And I'll definitely pray
I'll
for.
see both of you up there. That'd be
Yeah.
fantastic.
Oh, hopefully it's the dream. But yeah, no, thank you so much, Keir. So I mean, I could go on all day about questions and ask you all questions all day, but unfortunately, I know I can't. So is there anything else you'd like to add about Art Not Evidence, or anything else you'd like to tell anybody? Obviously, the 24th of September, I will put the link of the tickets in to the LinkedIn post as well, for people to attend. And you managed to get a lawyer from America coming over, is that correct?
Yeah, Eric Nielsen. who
Okay,
was
yeah.
he's actually an expert over there. He's a lecturer, but he is an expert on rap, and
Yeah.
he was the author or co-author of a book called Prosecuting Rap, very successful over in the States. He's acted in lots of courts, and including some death row cases, giving evidence about rap. And most recently, he was Young Thug's expert in the prosecution that he faced, and obviously was partially successful in after I think about a 9-month trial. So he's coming over to speak, and we've got some other guests speaking. But the most important thing is getting all of us together in this great location in Clifford Chance's offices, having a chat and sorting out how we will eventually, and I'm sure we will do this, get this legislation passed so we can level the playing fields and just make sure these trials are fair and just and not relying on stereotypes and tainted by racial bias. Shouldn't be happening in this day and age.
Absolutely. What would you say to baby barristers coming up now about how to keep and make sure that they stay true to themselves and their integrity is intact when it concerns this type of thing, with
Yeah, so I'd say it's hard. I think it's really, really difficult. And you've got to stay true to yourself at 100%. You've got to have a good network around you. So if you haven't had a good reception when you make your submissions, don't give up. Have a chat about it, and then go back and do it twice as hard on the next occasion. Because if you're talking about truth, then you should ultimately win. Yeah, it might not be the first occasion, second occasion, but ultimately you will win. And you've got to think about how you present your arguments. It's difficult talking about racism and institutional racism, particularly at the moment in this political climate. But it's important to do so. If that is, on your assessment, a factor in a prosecution. And I encourage any judges that are listening to what we're discussing here not to ignore it, not to refuse to engage with these arguments, but to encourage them. Because if there is racial bias in the prosecution, or there's a danger that the evidence, if put before a jury, will be used in such a way to evoke stereotypes, then name it. Name it in your judgment. Ask why that's going on, if that's what's going on by the prosecution, and if so persuaded, exclude it. But the argument needs to be vocalized and recognized. And that way, we're going to make a bit of progress.
Absolutely, yeah, and tackle the problem head on.
Big time. Talk about it.
Okay, well, thank you ever so much, Kia. I will
Pleasure.
this around as well on the LinkedIn and the social media as well. And thank you honestly ever so much for joining me this morning.
No, thank you for inviting me. And I'll see you on the 24th.
I'll see you on the 24th. Yeah, I hope everybody enjoys the episode. Thanks for watching as well. Thank you. How do I stop this recording?